The arrogant attorneys thought they were dealing with another pretty face who had gotten her position through connections when everything went catastrophically wrong. The stunning brunette justice they'd been dismissing as too young and beautiful for the Supreme Court had just delivered a constitutional ruling that destroyed the most powerful law firm in the country, ended dozens of legal careers, and rewritten constitutional law forever. What they didn't know was that the gorgeous woman they'd assumed was inexperienced was actually Justice Isabella "Iron Gavel" Sterling, the youngest Supreme Court justice in American history, and her constitutional expertise was about to change the legal system while ending everyone who had underestimated her. Welcome to Silent Hero Stories. Before we begin, tell us in the comments where in the world are you watching from today. And if you believe stories like this deserve to be told, hit that subscribe button. Now, let me tell you how supreme arrogance led to supreme justice. The law firm of Whitman, Cross and Amp Partners had built an empire on one fundamental belief: the Supreme Court could be influenced, manipulated, and controlled through the same combination of political pressure, media campaigns, and strategic connections that had made them the most feared legal organization in Washington, D.C. For over 20 years, senior partner Jonathan Whitman had perfected the art of Supreme Court manipulation. His strategy was elegantly simple: identify the personal weaknesses of individual justices, exploit their political vulnerabilities, and use a sophisticated network of media contacts and political allies to create public pressure that would influence their constitutional interpretations. Whitman's success rate was legendary among Washington's power elite. He had successfully influenced landmark cases involving corporate rights, environmental regulations, and federal authority by treating Supreme Court justices like politicians who could be pressured rather than constitutional scholars who interpreted law based on legal precedent. Which is why Whitman was particularly excited about the upcoming case of Morrison Industries v. Environmental Protection Agency, a constitutional challenge that would determine whether federal environmental regulations could override state corporate protections. The case was worth billions to his corporate clients, and victory would establish legal precedents that would benefit polluting industries for decades. But what made Whitman truly confident was his assessment of the Supreme Court's newest member, Justice Isabella Sterling, a 32-year-old constitutional law expert who had been appointed 6 months earlier amid intense political controversy about her age and qualifications. "Gentlemen," Whitman said to his legal team during their pre-case strategy meeting, "we're facing a Supreme Court that includes someone who looks more like a fashion model than a constitutional scholar. Justice Sterling is young, inexperienced, and clearly appointed for political reasons rather than legal competence." His associate, Marcus Cross, nodded with the confidence of someone who had spent 15 years treating female judges as obstacles to be overcome rather than legal authorities to be respected. "I've studied her previous rulings as a circuit court judge. She's technically competent but lacks the intellectual depth for complex constitutional analysis. More importantly, she's never faced the kind of political pressure we can generate." What neither Whitman nor Cross understood was that Justice Isabella Sterling's appointment to the Supreme Court hadn't been political favoritism, it had been the recognition by legal scholars across the political spectrum that she possessed the most sophisticated understanding of constitutional law of any jurist in the country. Isabella's record before joining the Supreme Court was something that Whitman's researchers had somehow failed to fully investigate. As a circuit court judge, she had authored constitutional opinions that were considered masterpieces of legal reasoning, earning her the nickname Iron Gavel from attorneys who had learned to fear her methodical approach to constitutional interpretation and her absolute refusal to be influenced by political pressure. Her academic credentials were equally impressive: Harvard Law School summa cum laude, Yale Law School Constitutional Law Fellowship, and a judicial clerkship with Chief Justice Roberts that had established her as one of the most brilliant legal minds of her generation. But her stunning beauty, long dark hair, emerald green eyes, and a face that belonged on magazine covers, had created assumptions about her intellectual capabilities that would prove to be the most dangerous miscalculation in Supreme Court history. The morning of oral arguments in Morrison Industries v. EPA began with Whitman's team arriving at the Supreme Court building with the confidence of gladiators entering an arena where they had never experienced defeat. The media attention was intense. The case would determine the future of environmental regulation and corporate accountability in America. Justice Isabella Sterling took her place on the Supreme Court bench wearing the traditional black robe that somehow managed to emphasize rather than conceal her remarkable beauty. To the assembled attorneys and legal observers, she appeared to be exactly what Whitman had described, a young woman who was clearly out of her depth in the highest court in the land. "Mr. Whitman," Chief Justice Roberts announced, "you may begin your arguments." Whitman approached the podium with the theatrical confidence of someone who had spent 2 decades manipulating federal courts. His opening statement was designed not just to present his legal arguments, but to subtly intimidate the younger justices while appealing to the political sensibilities of the more senior members. Chief Justice Roberts, honored justices, Whitman began with Practice Gravitas. The case before you today represents a fundamental challenge to the constitutional balance between federal authority and state sovereignty. The EPA's environmental regulations represent an unprecedented expansion of federal power that threatens the very foundation of our federal system. His argument was sophisticated, well-researched, and delivered with the kind of commanding presence that had successfully influenced dozens of federal cases. But as Whitman continued his presentation, he began to notice something unexpected. Justice Sterling wasn't showing the deference or uncertainty he had anticipated from someone he considered intellectually inadequate for Supreme Court service. Instead, she was taking extensive notes, reviewing constitutional precedents, and preparing questions with the kind of methodical precision that suggested far more legal sophistication than Whitman had expected from someone he had dismissed as a political appointee. "Mr. Whitman," Justice Sterling said when he paused for questions, her voice carrying clearly through the Supreme Court chamber with an authority that made everyone present pay attention, "your argument relies heavily on the Commerce Clause interpretation established in United States v. Lopez. Are you familiar with the constitutional analysis in subsequent cases that have expanded federal regulatory authority?" The question hit Whitman like a physical blow. Justice Sterling had just referenced one of the most complex areas of constitutional law and demonstrated an understanding of Commerce Clause jurisprudence that rivaled the most experienced Supreme Court advocates. "Of course, Justice Sterling," Whitman replied, but his voice carried a nervous edge that suggested he was beginning to realize he might have seriously underestimated his opponent. "However, I believe the Lopez precedent clearly establishes limitations on federal authority that apply to this case." "I see," Justice Sterling replied with a slight smile that should have warned Whitman he was walking into a constitutional law trap that had been set by someone operating at a level of legal sophistication he had never encountered. "And how do you reconcile that interpretation with the court's decision in Wickard v. Filburn, which established federal authority over local activities that substantially affect interstate commerce?" The follow-up question revealed that Justice Sterling wasn't just familiar with constitutional precedent, she was demonstrating a mastery of Commerce Clause interpretation that surpassed Whitman's own understanding despite his 20 years of Supreme Court practice. "Justice Sterling," Whitman said, his confidence beginning to crack under the pressure of facing genuine constitutional expertise, "I believe Wickard v. Filburn represents a different category of federal authority that doesn't apply to environmental regulations." "Really?" Justice Sterling asked, her emerald eyes showing the kind of predatory focus that had earned her the nickname Iron Gavel among circuit court attorneys. "Because the environmental contamination at issue in this case crosses state boundaries, affects interstate commerce, and involves exactly the kind of substantial economic impact that Wickard identified as subject to federal regulation." The exchange was devastating. Justice Sterling had just demonstrated that she understood the constitutional issues better than the attorney who had spent months preparing to argue before her. But more importantly, she had revealed that her legal analysis was sophisticated enough to identify the fundamental weaknesses in Whitman's constitutional arguments. During the lunch recess, Whitman confronted his research team with barely controlled panic. The beautiful young justice he had dismissed as intellectually inadequate was systematically destroying his carefully prepared constitutional arguments with a level of legal expertise that suggested he had made a catastrophic error in judgment. "Who the hell is Isabella Sterling?" Whitman demanded, his usual composure cracking under the pressure of watching his Supreme Court strategy collapse in real time. "She's not some political appointee. Nobody develops constitutional law expertise like that without serious academic and judicial experience." His lead researcher, Sarah Mitchell, looked up from her laptop with the expression of someone who had just discovered information that would change everything. "Mr. Whitman, I think we have a serious problem. I've been reviewing Justice Sterling's academic and judicial record, and we missed some crucial information." "What kind of information?" Whitman asked, though his tone suggested he already suspected the answer would be devastating. "She's not just Harvard Law summa cum laude," Mitchell replied quietly. "She was editor-in-chief of Harvard Law Review, authored the definitive Law Review article on Commerce Clause interpretation, and clerked for Chief Justice Roberts before becoming the youngest circuit court judge in history." The revelation that Justice Sterling had literally written the academic analysis of the constitutional law that Whitman was trying to argue was the final confirmation that he had walked into a legal confrontation with someone operating at a level of constitutional expertise that he couldn't match. "There's more," Mitchell continued with growing horror. "Her circuit court opinions on constitutional law are considered masterpieces of judicial reasoning. She's authored precedent-setting decisions on federal authority, environmental law, and corporate regulation. Legal scholars across the political spectrum consider her one of the most brilliant constitutional minds of her generation. Whitman was staring at his researcher with the expression of someone who had just realized that the beautiful young woman he had dismissed as inexperienced was actually one of the most formidable legal intellects in American history. And Mr. Whitman, Mitchell added with devastating finality, attorneys who have appeared before her circuit court call her Iron Gavel because she's never been influenced by political pressure and has never reversed a constitutional ruling based on external pressure. The afternoon session of oral arguments began with Justice Sterling asking questions that revealed the true extent of her constitutional expertise. Her inquiries were surgical in their precision, targeting the exact weaknesses in Whitman's legal theory while demonstrating an understanding of environmental law and federal authority that exceeded anything he had encountered in decades of Supreme Court practice. Mr. Whitman, Justice Sterling said, her voice carrying the kind of authority that made everyone in the Supreme Court chamber pay attention, your argument suggests that federal environmental regulations exceed constitutional authority because they interfere with state corporate law. Are you familiar with the precedent established in Gibbons v. Ogden regarding federal authority over interstate commerce? Whitman felt sweat forming on his forehead as he realized that Justice Sterling was citing constitutional precedent from 1824 to demolish his 21st century legal arguments. Her knowledge of constitutional history was so comprehensive that she could reference 200-year-old cases with the same precision that most attorneys cited recent decisions. Of course, Justice Sterling, Whitman replied, but his voice lacked the confidence he had displayed during his morning presentation. However, I believe Gibbons v. Ogden established different principles that don't apply to modern environmental regulation. I see, Justice Sterling replied with a smile that revealed she was about to deliver a constitutional law lesson that would be remembered by legal scholars for decades. So you're arguing that the Commerce Clause authority established by Chief Justice Marshall in 1824 doesn't apply to interstate environmental contamination in 2024? The question was devastating in its simplicity. Justice Sterling had just demonstrated that Whitman's constitutional argument was inconsistent with 2 centuries of Supreme Court precedent, and she had done it with such elegant precision that everyone in the chamber understood she was operating at a level of legal sophistication that Whitman couldn't match. Justice Sterling, Whitman said, his voice showing the desperation of someone who had just realized his legal strategy was collapsing, I believe modern constitutional interpretation allows for different applications of Commerce Clause authority. Certainly, Justice Sterling replied with the kind of predatory satisfaction that warned everyone present that she was about to deliver the final blow to Whitman's constitutional arguments. Modern constitutional interpretation does allow for evolution in Commerce Clause application. Which is why your argument fails under both historical precedent and contemporary constitutional analysis. She paused, letting her words settle over the silent Supreme Court chamber. Mr. Whitman, are you familiar with my law review article on Commerce Clause evolution and environmental authority, published in Harvard Law Review 3 years ago? The question hit the courtroom like a thunderbolt. Justice Sterling had just revealed that she had literally authored the definitive academic analysis of exactly the constitutional issue that Whitman was trying to argue before her. I'm not certain I've reviewed that particular article, Whitman admitted, his voice barely above a whisper. It's quite relevant to your argument, Justice Sterling replied with quiet authority that made everyone present understand they were witnessing a historic moment in Supreme Court jurisprudence. In fact, it specifically addresses the constitutional arguments you've presented today and explains why they're inconsistent with both historical precedent and modern Commerce Clause interpretation. The admission that the nation's leading Supreme Court advocate was unfamiliar with the constitutional analysis written by the justice he was arguing before was one of the most humiliating moments in Supreme Court history. But Justice Sterling wasn't finished with her constitutional demolition of Whitman's legal strategy. During the government's presentation defending the EPA regulations, her questions revealed that she had spent months preparing for this case with the same methodical thoroughness she had brought to every constitutional issue throughout her judicial career. Ms. Rodriguez, Justice Sterling said to the government attorney defending the EPA regulations, can you explain how the environmental contamination documented in this case demonstrates the kind of substantial effect on interstate commerce that justifies federal regulatory authority under current Commerce Clause interpretation? The government attorney's response was comprehensive and well prepared, but Justice Sterling's follow-up questions revealed that she had studied every aspect of the case with academic precision that exceeded even the government's own legal analysis. Ms. Rodriguez, I've reviewed the environmental impact studies submitted as evidence in this case. The contamination affects water supplies in 7 states, agricultural products shipped nationwide, and manufacturing processes that are integral to interstate commerce. Would you agree that this represents exactly the kind of interstate economic impact that federal authority is designed to address? The exchange made it clear that Justice Sterling hadn't just studied the legal precedents relevant to the case, she had analyzed the scientific evidence, economic data, and environmental studies with the thoroughness of someone who understood that Supreme Court decisions must be based on both legal precedent and factual accuracy. When oral arguments concluded, legal observers and media representatives were struggling to process what they had witnessed. The beautiful young justice that many had assumed was inexperienced had just demonstrated constitutional expertise that surpassed the most experienced Supreme Court advocates and revealed legal analysis that would reshape environmental law for generations. But the true extent of Justice Sterling's intellectual dominance wouldn't be revealed until the Supreme Court issued its decision 3 months later. Her majority opinion in Morrison Industries v. EPA would be recognized as one of the most important constitutional decisions in American history, and one of the most devastating professional destructions ever delivered by the nation's highest court. Justice Sterling's opinion was a masterpiece of constitutional analysis that systematically demolished every aspect of Whitman's legal strategy while establishing precedents that would govern environmental law for decades. But more importantly, her opinion included a rare judicial rebuke that would end Whitman's career and reshape how attorneys approached Supreme Court practice. The arguments presented by Morrison Industries counsel, Justice Sterling wrote in her majority opinion, represent a fundamental misunderstanding of constitutional precedent that suggests either inadequate preparation or deliberate misrepresentation of established legal principles. The judicial criticism was devastating enough, but Justice Sterling's constitutional analysis went further, exposing the political manipulation tactics that Whitman had used in previous cases and establishing new ethical standards for Supreme Court advocacy. This court notes with concern the pattern of external pressure campaigns and political manipulation attempts that have accompanied this case, her opinion continued. Such tactics represent a fundamental misunderstanding of judicial independence and constitutional interpretation that undermines the integrity of our legal system. The Supreme Court's decision was unanimous in favor of the EPA, but Justice Sterling's concurring opinion included constitutional analysis that established her as the intellectual leader of the court and the definitive authority on environmental law and federal regulatory power. More importantly, her opinion included language that triggered bar investigations into Whitman's previous cases, leading to discoveries of systematic ethical violations, client fraud, and court manipulation that would result in criminal charges and the complete destruction of Whitman, Cross and Amp partners. Jonathan Whitman's 20-year career ended not with retirement or professional recognition, but with disbarment proceedings that revealed decades of legal malpractice and court manipulation. The attorney who had dismissed Justice Sterling as too young and beautiful to understand constitutional law learned that some people earn their judicial authority through intellectual brilliance rather than political connections. Marcus Cross received similar professional sanctions, and the law firm that had built its reputation on Supreme Court manipulation was disbanded after federal investigations revealed systematic violations of legal ethics and client trust. Justice Isabella ironed Gavel Sterling's majority opinion in Morrison Industries v. EPA became required reading in constitutional law courses across the country. Her intellectual demolition of corporate legal arguments while establishing precedents for environmental protection demonstrated why she had been appointed to the Supreme Court at such a young age. The gorgeous brunette they had assumed was inexperienced had just authored one of the most important constitutional decisions in American history while ending the careers of everyone arrogant enough to believe that beauty and youth were signs of intellectual inadequacy rather than camouflage for legal brilliance. Legal scholars would later describe Justice Sterling's opinion as a perfect demonstration of why constitutional interpretation requires intellectual rigor rather than political manipulation. Her methodical analysis of 2 centuries of Commerce Clause precedent, combined with sophisticated understanding of environmental science and economic impact, established new standards for Supreme Court decision-making. But most importantly, her judicial rebuke of attorney misconduct established ethical precedents that would prevent future attempts to manipulate the Supreme Court through political pressure campaigns and media manipulation. The stunning woman they thought they could dismiss as a political appointee had reminded the entire legal profession that Supreme Court justices earn their positions through constitutional expertise, judicial temperament, and intellectual brilliance, qualities that have nothing to do with age, gender, or physical appearance. Justice Isabella Sterling had spent 6 months on the Supreme Court while attorneys like Whitman dismissed her as too young and beautiful to understand constitutional law. But those 6 months had given her everything she needed to demonstrate that some people achieve judicial authority through academic excellence, legal brilliance, and ethical integrity rather than political connections and court manipulation. The youngest Supreme Court justice in American history had just delivered one of the most intellectually sophisticated constitutional opinions in the court's history while destroying the careers of everyone who had underestimated her based on her appearance and age. Her nickname Iron Gavel proved prophetic. Once she made a constitutional ruling based on legal precedent and intellectual analysis, no amount of political pressure or professional intimidation could change her position. The beautiful young woman they assumed was inexperienced was actually the most intellectually rigorous justice on the court, someone whose constitutional expertise would reshape American law for generations. The stunning brunette they had dismissed as too pretty for serious judicial work had just proven that sometimes the most dangerous person in a courtroom isn't the loudest or most experienced, it's the one who actually understands constitutional law well enough to distinguish between legal precedent and political manipulation, and has the intellectual courage to base judicial decisions on legal principle rather than external pressure. Supreme Court historians would later describe Morrison Industries v. EPA as the case that established Justice Sterling as the intellectual leader of the court and demonstrated why constitutional interpretation requires legal brilliance rather than political sophistication. The gorgeous young woman who had appeared inexperienced to her critics had actually been the most prepared, most knowledgeable, and most intellectually sophisticated participant in one of the most important constitutional cases in American history.